Morning all, you're very welcome to this morning's CPD on the topic of common amendments to the ORIAI standard form of contract. My name is James Lonergan, I'm Director of Education on CPD with the SCSI, and you're all very welcome. Just before I introduce our speakers this morning, just a couple of housekeeping items. Today's CPD will be 1 hour CPD is available for today's CPD. We are recording this morning, so the recording will be available to you afterwards. If you have any questions during the CPD, please use the Q&A function and post your question in there. We'll take questions at the end as time allows. Excuse me. And we have contact details for the speakers on screen so that you can contact them offline as well. Excuse me. So just to introduce the speakers this morning, Margaret Alston is a partner in property and construction and head of construction planning and environment law group at Eugene F. Collins. She advises contractors, developers, funders, and professional teams at all stages of a construction project, both contentious and hopefully more so non-contentious. Her advice covers the range of construction project documents, including development agreements, agreements for lease, building licenses, construction contracts, performance bonds, collateral warranties, and construction funding agreements for projects, as well as statutory compliance requirements under the construction regulations and under the building control regime. We're also joined this morning by Siobhan Kenny, who's an associate in the property and construction group at Eugene F. Collins. With over 20 years of experience, Siobhan acts on behalf of a broad spectrum of clients involved on the construction law aspects of building projects, both contentious and non-contentious. You're both very welcome and thanks for joining us again. I'll pass over now to Siobhan. Thanks.
It's myself actually, James. Well, good morning everybody, and thank you very much for joining us this morning. And this morning we're going to talk about common amendments to the ORIAI standard form of contract. When I talk about the ORIAI standard form, for the purposes of Siobhan and my talk this morning, we're talking about the ORIAI blue form, where quantities do not form part of the contract, and we're talking about the 2017 edition. On the basis that's the form that we most commonly come across for commercial private projects in Ireland. So the standard ORIAI form of contract has been around for a number of years and has been subject to various amendments and reissues over the decades. But it's a form of contract which the industry is familiar with, and construction professionals are familiar with its terms, and contractors are familiar with pricing the risk under the contract. However, for certain projects, the employer may introduce a schedule of amendments. And there may be a number of reasons for that. So the employer may be obtaining finance for the development, and the funder may want to shift certain risks back to the contractor or want to insert funder-friendly clauses in the contract. There may also be a prospective purchaser or tenant for the works, and the employer in drafting the contract documents may be cognizant of their requirements in relation to, say, remedying of defects or future remedies such as collateral warranties in favour of the tenant or future purchaser of the works. And their solicitors may indeed be carrying out due diligence of the construction documents, and they may also want certain amendments made to the construction contract. There may also be project-specific or site-specific requirements that the employer wants to address in any schedule of amendments. So if it's work on a very tight urban site or adjacent to railway lines or overhead lines, then there may be specific additional clauses to deal with those requirements. Then, and currently we see that with Brexit and COVID arising, employers and contractors will want to set out how they are going to deal with those twin issues and the impacts and significant impacts of those events on the construction project. So again, specific additional clauses may be drafted to deal with those and the impact of those on the project and who's to bear the risk of those events. So we'll be looking at common amendments to standard forms, and Siobhan is going to look at from clause 1 to 29, and then I look at from clause 30 to 38, and in addition I look to some further clauses that are sometimes added to the contract. And we'll consider the purpose of each of these amendments, why it's done and why the changes are actually made. And I'm going to hand over to Siobhan, who'll talk to you from now. Thank you.
Good morning, everyone, and thank you, Margaret. As Margaret said, I'm going to deal with some of the more commonly amended conditions to the contract within the range of conditions 1 to 29. Not every clause, you'd be thankful to know, but just the ones that are most commonly amended in a heavily amended contract or a schedule of amendments. So the first of these is obviously condition number 1. And the reason that this clause is amended is really to take account of further amendments to the contract, because this is where you find a definitions clause. As drafted in the standard form, the only term which is actually defined is the term designated date, and that's linked to condition 36, the wage and price variation clause. Where a contract is to be amended, where a schedule of amendments is going to be presented to a contractor, the definitions clause will almost invariably be expanded to include all terms which are going to be used throughout the schedule of amendments. It's a very informative condition to have regard to, because the meanings attributed to individual terms can differ from contract to contract depending on the intentions of the employer through the use of a particular term or the introduction of a particular concept. The other aspect of condition 1 is the interpretation section, which is rarely amended, but if it is amended, care should be taken to note such amendments. And one that springs to mind is the possible amendment of the meaning of days. It may be that in the standard form of contract, days are taken to mean working days. If that's changed to calendar days in the interpretation section, that's an important issue to note for the parties to the contract, because that will be linked in with notice periods arising under the contract. So it is any change to the interpretation section should be reviewed carefully. Condition number 2, which is the next condition I'm going to look at, is really at the heart of the contract. This is where, under the standard form, the obligations of the contractor to carry out the project in accordance with the contract documents is set out. His obligation to comply with architect's instructions and the list of the categories of instructions which may be issued are set out. In addition, this condition deals with how additional costs arising from compliance with an architect's instruction are to be dealt with. Where there are variations, they're to be evaluated under condition 13, and where they are not valuations, where they are loss and expense arising as a result of compliance with an architect's instruction, under the standard form, the architect is required to assess that level of cost and expense with a view to adding it to the contract sum. And the final element of condition 2, as drafted in the standard form, deals with the right of the employer to call on others, on third-party contractors, to complete works should the contractor fail to do so. This clause, this condition, is commonly amended. If there is going to be a schedule of amendments, a lot of attention will be paid by the drafter to condition number 2. And one of the things that drafters will do is set out the number of issues to which the contractor must have regard whilst carrying out the works. So this is an expansion from contract documents. We often see that the contractor is charged with having regard to the law, to consents such as planning permissions, or authorizations such as the fire safety certificate and any conditions attached to that, to building regulations and building control regulations. This is also the destination of project-specific requirements. So as Margaret said, if the works are to be undertaken on a particularly congested site, you might often find an amendment in condition 2 setting out those particular constraints and charging the contractor with responsibility to have regard to them. We also see that this is where the employer will seek a number of warranties and confirmations from the contractor with regard, for example, to the level of skill and expertise required to carry out and complete the project. The contractor might be asked to confirm in condition 2 by way of amendment that the contract sum that he has tendered is adequate to carry out and complete all of the contract works. He may be asked to confirm and acknowledge that he's had an opportunity to visit the site and is familiar with the site, the conditions pertaining to it, and any constraints which may be visible on inspection. And another common requirement is that the contractor acknowledges that he's taken account of services and utilities in the vicinity of the site and for the purposes of connection to them. We often see as well that this is the venue for contract management provisions, such as requirements for the frequency of site meetings and how minutes are to be dealt with, possibly for the reporting obligations arising under the contract, the obligation to provide progress reports and to update programs may be contained in condition 2. And there will almost invariably be a requirement for an ongoing engagement with the architect, notifying the architect of any events which may cause a problem on site or difficulty to the contractor in performing his obligations. The intention behind these amendments is for the employer to set out transparently, clearly, and coherently his expectations of the contractor when undertaking the works. It's also the purpose of this amendment is an acceptance of risk on the part of the contractor. By setting out these issues clearly in condition 2, the contractor is afforded an opportunity to price the risks, the additional risks that he's being asked to undertake. As I said, the next issue which arises under condition 2 is the obligation to comply with architect's instructions and the treatment of any additional cost arising from compliance with architect's instructions. Again, condition 2 is often used as the condition under which a claims procedure will be introduced. We frequently see that the claims procedure included in an amended contract is aligned with the 10.3 GCC procedure, which, as you will be aware, has a condition precedent notice requirement followed up by a condition precedent details provision under which, within given timeframes, the contractor is required to take action. The procedure will often set out notice periods and consequences of failure to comply with those procedures. And it's important from the contractor's perspective that any procedure or protocol set out in the main contract for claims is mirrored in subcontracts so that the contractor protects himself in his underlying contracts which lie beneath the main contract. The purpose is clear. The purpose of having a procedure like this is so that at the earliest opportunity, the employer is alerted to potential claims and can make arrangements and adjustments to his plans for the project to take account of claims. Early notification also can result in dispute avoidance. If issues are identified at the earliest possible stage and disposed of at the earliest possible stage, that leads to a smoother running project. So that brings me to the end of condition 2, which is, as I say, at the heart of the contract. The next condition I'm going to look at is condition number 4, legislative changes. And the reason that I've picked this condition out is because it's assumed very significant importance over the past 12 months. Traditionally, in the standard form, this clause fixes the employer with contractual responsibility for additional cost arising from changes introduced by the government to taxes, to import duties, to any kind of levies that are to be imposed on construction products or on construction projects. It also includes a term where a legislative change is introduced which impacts on the cost of labour. The contractor will be entitled to recover that additional cost under the traditional form of condition 4. We frequently see this clause amended even before the pandemic. Changes were being made notably to exclude particular types of legislation which were in contemplation or anticipated at the time the contract was being executed. And the example that I've set out there on the slide is sexual employment orders. In the lead up to the introduction of the sexual employment orders, a number of contracts, of amended contracts, would exclude the impact of the SEOs from the legislative change cost recovery. At the moment, we're seeing changes to this clause to take account of Brexit and the SEOs, because that issue is still very much up in the air. And of course, the pandemic law introduced to deal with the consequences of the pandemic. The reason for this change is that the employer's intention in entering into a contract such as this is to enter into a fixed price lump sum kind of arrangement that he can go to his funder with, assured in the knowledge that, subject to any variations which may be instructed, the cost of procuring his project will not increase. So therefore, the employer is intent, when amending the contract or amending this condition, in passing contractual risk to the contractor. The contractor on the far side of the table, again, gets the opportunity to price that risk and include it in his tender price. The next condition that I have selected for some attention this morning, because obviously time doesn't allow us to go through every single amendment which might be introduced into a contract, is condition 10, dealing with site manager and foreman. And on its face, in the standard form, this is a very simple and straightforward provision, which requires the contractor to make sure that somebody who's experienced and competent is appointed to have custody, day-to-day custody of the project. The reason that I've included this, this condition for attention is this is quite often the clause under which the employer will introduce a far more elaborate requirement on the part of the contractor in respect of key personnel, and identifying at contract stage the people who will be responsible, again on a day-to-day basis, for delivery of the project. Now, that change can either be made in this condition, or, as Margaret will point out in her part of the presentation, may form a brand new condition which is added to the end of the schedule of amendments. But again, the purpose of this condition is that the employer is seeking visibility and assurance with regard to the fact that experienced people will be engaged in his project and the delivery of the works, and allows them to have confidence in the management structure and the management approach being taken by the contractor. The requirement here is to ensure continuity. So we'll often see restrictions on the right to substitute personnel, key personnel, during the course of the project. The variations clause, the value of variations, is dealt with under condition 13, and the means of valuation is very rarely amended. There are several options available to the architect in evaluating a variation in the standard form, and that is rarely changed. But what is changed is a strengthening of the procedure involved in claiming a variation, or indeed instructing a variation. The amendments will often reflect the fact that the employer requires that any variations are to be instructed in writing, and if not initially instructed in writing, are to be confirmed in writing within a given time period. This is all about transparency and visibility of contingent liabilities arising or pressure being placed on the employer's project budget. So the sooner the employer is aware of and alerted to variations and claims for variations, the more visibility he has with regard to the progress of the works. We often also see the introduction of a procedure for a proposed variation, where the contractor and the employer will agree in advance the time and cost implications of a proposed variation before it's in fact instructed. Again, early identification of variations, early identification of the cost and time implications of any instructed variation ensures there are no surprises at the end of the day, whether at interim stage or at final account stage, and allows the parties to avoid problems, difficulties, or disputes. Enhanced visibility arising through these procedures and administration of these procedures will aid in the smooth progress of the project. I've grouped conditions 15, 16 and 17 together because these deal with a number of concepts about subletting the contract, about assignability of the contract, and about the concept of nomination. The common amendments that we see to these clauses, in the first of these common amendments is assignability. Clearly the contractor will never be permitted to assign the whole of the contract to anyone. But the employer will require a degree of flexibility to either assign the benefit of the contract to a funder, or possibly to novate the benefit of a contract to a third-party purchaser or tenant to whom he sells the benefit of the contract he's entered into with the contractor and disposes of the entire project. So quite often, and these may be project-specific amendments, we will see changes to the assignability of the contract, which is condition 15. When it comes to subcontractors, the message that is coming through the schedules of amendments that we review regularly is that the employer has no interest whatsoever in retaining responsibility for work undertaken by subcontractors of any tier, whether they are specialist, design, pure domestic, or nominated. And it's the concept of nomination which fixes the employer with a degree of responsibility for design provided by nominated subcontractors. So the most common amendment that we see to condition 16 is its deletion to eliminate the concept of nomination and its replacement with very detailed provisions dealing with the engagement of specialist or design subcontractors and how they are to be managed, the requirements for the provision of insurances, of intellectual property licenses, and the obligation to provide collateral warranties. So we see the nomination system completely replaced with provisions dealing with design and specialist subcontractors. If condition 16 is treated in that way in a schedule of amendments, that will then have a knock-on effect on condition 19, which deals with prime cost, and on condition 24 by deleting the reference to nominated subcontractors and suppliers from that clause. So the intention behind these wholesale changes in respect of subcontractors is to pass to the contractor full contractual risk and responsibility for all work done by all subcontractors, however they're introduced to the contract and whatever element of the works they're performing. And this is very much in line with condition 5 of the GCC form of contract. The next condition I've selected for particular attention is condition number 20. And the reason I've selected this is because this relatively straightforward clause in the standard form of contract, designed primarily to allow the employer to introduce his own fit-out contractors, is very commonly amended to fix the contractor with a responsibility for coordination of all activities if direct contractors are being brought onto the project, to provide for things such as attendances and an access protocol. So the employer will take the opportunity in condition number 20 to set out his requirements of the contractor in its engagement and interface with direct contractors who are coming to the site and the project at the behest of the employer. The employer will confirm to the contractor through these amendments that in introducing such direct contractors, he will ensure that such entities are required to comply with the contractor protocols, for example, for health and safety, and for coordination and for engagement and interface with the contractor and his team working on site. We've also seen this clause used in a management contractor type of scenario, where condition 20 is heavily amended to manage the coordination of a number or a series of direct contractors, all brought to site by a management contractor who has an umbrella role over the management of the project. The insurance clauses, which are set out in the standard form, conditions 21 through to 24, the substantive elements of the insurance provisions, those dealing with the risks which require to be covered, and how and which of the two parties is to retain responsibility for those insurable risks, are rarely changed. And the reason for that is that the insurance providers, those who sell insurances to the contractors and to employers involved in projects, are very familiar with the terms of these standard forms of contracts and the risks which are required to be covered. And any interference or change in those risks should only be undertaken with the greatest of care and with the advices of insurance advisors. However, amendments are commonly made to these provisions to accommodate the interests of funders, tenants or purchasers, to provide for the noting of their interests on insurance policies, to provide for an obligation to comply with any conditions attached to insurances, and also to provide for claims being made under insurance policies and how the proceeds of those claims are to be managed and distributed. Quite often these changes come about as a result of requirements of funders with regard to those insurances which are available during the currency of the project. We also see, in particular, if condition 16 has been amended as outlined, a requirement for the contractor to put in place and maintain professional indemnity insurances for the life of the project, and to make sure that any subcontractors providing design elements are similarly insured and provide evidence of that throughout the life of the project and beyond through the liability period. The final clause I'm going to look at is condition 28, dealing with dates for possession and completion. The change here is usually a relatively minor one in terms of the words used, but it can have significant impact on site. And that is to ensure that the contractor's license to occupy the site is intended to be a non-exclusive license, as opposed to the exclusive license which is provided for in the standard form. This is to ensure that the employer and his appointees or nominees may have access to the site as required throughout the life of the project, subject, of course, to compliance with health and safety protocols put in place by the contractor, and in particular having regard to the contractor's obligations as PSCS. This condition may be used to introduce a requirement for a programme and the constant updating of that programme during the currency of the works. So that is my whistle-stop tour of the first part of the contract, and I'm now going to pass back to Margaret, who's going to deal with the balance of the contract and any additional clauses. Thank you.
Thanks, Siobhan. So I'm going to look at some of the clauses from clause 30 to 38, and then also some additional clauses that might be added to the schedule of amendments. Clause 30 of the contract deals with the circumstances in which the contractor might be entitled to claim for delay and extension of time. Sometimes in a schedule of amendment, we'll see further clarification of terms used in that clause. So for instance, force majeure isn't actually defined. So sometimes in a schedule of amendments, you'll see clarification of what is covered by force majeure and what are force majeure events. And in particular now, with people looking very closely at force majeure clauses, you may see an exclusion of COVID as being a force majeure event, a specific exclusion, and you might see a clause that specifically addresses COVID and or any other pandemic and how they are to be dealt with as between the employer and the contractor and the allocation of risk in relation to that. Exceptionally inclement weather isn't defined, and you might also see that that's aligned by amendment with the definition under the GCCC form of contract. A weather event there is defined, and sometimes you'll see that definition adopted. Civil commotion, strike and lockout might be limited such that it doesn't apply to any strike by subcontractors of the contractor. So again, you can see clarification of some of these terms to clarify precisely when or the circumstances in which the contractor would be entitled to look for an extension of time. You might also see amendments in a schedule of amendments to deal with the procedural requirements on making an application for an extension of time. So under RII, the contractor is obliged to immediately give notice upon the happening of any event. But quite often in schedules of amendments now, you'll see the procedures being aligned with the procedures under clause 10.3 of the GCCC form of contract. And as Siobhan referred to earlier, the detailed procedural requirements there that require the giving of notice, and then within a defined period, say 21 days thereafter, a further notice of the details with all the detailed particulars of the actual claim. So setting out the extension of time sought, the adjustment to the contract sum sought, and the impact of the extension on the programme for the works. Clause 31 of the contract deals with practical completion and defects liability. And again, sometimes in schedules of amendments, you'll see amendments to the requirements around practical completion. So in some instances, you'll see a requirement that the contractor give notice to the employer, say 21 days in advance of the likely anticipated practical completion date, and giving the employer and maybe the funder's project monitor or the purchaser's project monitor an opportunity to inspect the works prior to practical completion, and for them to have an input in relation to the drawing up of lists of matters that need to be attended to prior to certification of practical completion of the works. You might also see the drafting of a list of documents that are to be provided as a condition of practical completion. So we can't and haven't today looked at all of the amendments that would be required to the RII form of contract to modify it for a design and build project. But if you were dealing with a design and build project, then in particular under these clauses, you would be setting out all of the documents that would be required, including opinions and certificates on compliance. What this clause would also be the opportunity to ensure that you get the contractor collateral warranties and the design subcontractor collateral warranties in favour of any funder or any future purchaser or tenant of the works. Because it is at this point where practical completion is about to happen, where you have the particular leverage to ensure that you get those documents that you require. So you might also look for production of the draft safety file with the full and complete safety file to be provided maybe 2 weeks there, or a couple of weeks thereafter. If there's specialist plant and equipment in the works, you might also look for operating manuals, product warranties, manufacturer's guarantees in respect of those. You might look for the as-built drawings. You might require that the contractor provide copies of the ancillary certs. In some clauses, we've also seen a requirement that the works be registered on the BCMA register. However, more and more, we're no longer seeing that, because I think it's widely regarded that whilst the contractor has to provide much of the documentation for that process, it isn't appropriate that certification of practical completion be dependent on achieving that, where it's a process that's outside of the contractor's control. It's a third-party procedure. Sometimes you'll also see changes in relation to the defects liability period, because under the standard form or RII form of contract, the contractor is to come back within a reasonable period of time of receipt of the architect's instructions. But sometimes you'll see a requirement in a schedule of amendments that the contractor come back within 21 days or 30 days to remedy a defect, again giving clarification and tightening up the timeline within which those defects are to be remedied. You may also see amendments in a schedule of amendments to clause 35 on certificates and payments. Often you'll see deletion of the requirement that a specific guarantee account be set up and funds lodged in that account to give comfort to the contractor in respect of the presentation of interim certificates. You'll see deletion of that requirement, and you may also see deletion of the requirement that the employer provide a certificate from its bank confirming that there's sufficiency of funds to meet the cash flow requirements of the project. These are very much kind of pro-employer deletions. You may also see deletion of the specific requirement that a joint account be set up in respect of the retention fund, and the clause simply that the retention monies will be held on trust. Often in a schedule of amendments, you'll also see an amendment dealing with the consequences of the issue of the final certificate. So the final certificate under the RII contract has the effect that the works are properly carried out and completed, and that there are no further adjustments to be made to the contract sum, provided that there's been no fraud, well, except it's conclusive except by reason of fraud, and except in respect of defects that a reasonable inspection wouldn't have disclosed. But again, you may see amendments in a schedule of amendment to provide that the final certificate is conclusive only as to monies. So conclusive only as to the balance of the monies due between the employer and the contractor, and that there are no outstanding claims and there'll be no further adjustment to the contract sum, and it doesn't have any impact on the employer's ability to claim in respect of defects. Invariably, clause 36 on wage and price variation is deleted, and you'll see a provision that the contractor is to be liable for any increase in rates of wages or expenses and the costs of materials, goods, etc. Clearly now, with the twin impacts of Brexit and COVID giving rise to the delay of supply of materials to site, so you understand steel from China is coming from China is a significant issue because that's been delayed due to COVID, and then with supply issues arising from Brexit, deletion of clause 36 is a serious concern for a contractor, but invariably that clause is deleted. Clause 37 of the standard RII form provides that the contractor may provide collateral warranties from the subcontractors in the standard RIAI form as approved by the CIF and SCSI. However, invariably, if the employer is obtaining funds, development finance for the development, then that will be amended to provide that the contractor is to provide a form of collateral warranty in favour of the funder in the funder template form, which is generally attached or appended to the building contract as a schedule to the contract. Likewise, you'll also see a requirement that the contractor procure from its design subcontractors forms of collateral warranty in favour of the funder, and again in the template form to be attached to the contract. And these are particularly important from the funder's perspective because they give the funder the step-in rights that the funder will require if there's any default by the employer borrower under the finance documents. And these step-in rights will allow the funder to step into the employer's shoes on the building contract or into the contractor's shoes under the design subcontracts. There may also be a requirement for the provision of collateral warranties in respect of any future purchaser or tenant of the works. And again, the form of those collateral warranties can be attached to the building contract, and the contractor will be aware that it then has to sign collateral warranties in favour of the purchaser or tenant in the agreed form and procure from an agreed list of design subcontractors collateral warranties in favour of any future purchaser or tenant of the works. In clause 38, sometimes you'll see reference to the availability of adjudication for payment claims. However, it's not strictly speaking necessary because that's a process that arises under statute in any event and is available. Sometimes, however, you will see an amendment to provide that the parties agree that should a dispute arise that's referable under that act, that the parties agree a named adjudicator would resolve those disputes. So rather than having to go to the minister or the ministerial panel for the selection of an adjudicator, the parties agree that a certain party would be the adjudicator for the purposes of any such disputes. As I mentioned, we haven't dealt with all of the amendments that would be required for a design and build contract because there's so many that would be beyond the scope of the talk today. But just to mention, if you were modifying the RRI for design and build, you would need to look in particular at modifying the obligations in relation to the design and construction of the work, so that the contractor would be liable for both the design and construction of the works. And you would be looking at inserting requirements for collateral warranties to cover contractor design and subcontractor design, and obligations in relation to putting in place appropriate levels of PI insurance and maintaining that insurance in place, and ensuring that all of those parties give intellectual property rights in respect of the design materials generated by them. Sometimes you'll see an additional clause dealing with deleterious materials or prohibited materials, and putting an obligation on the contractor that the contractor isn't to use any materials that are contrary to any specifications or Irish and European codes and standards, and that are known or reasonably suspected to be deleterious, or materials that are capable of posing a threat to the stability or integrity or performance of the structure. You might also see specific requirements or clauses dealing with the programme. And Siobhan mentioned that earlier, but if it isn't dealt with in clauses 1 to 38, sometimes you'll see an additional clause dealing with the employer's specific requirements in relation to programme. And again, the funder may also have an input here in terms of the package used for generation of those programmes, how often they're to be revised, and the information to be provided to the project monitor, and any progress reports also. You might also see additional clauses added to the contract to deal with the requirement for a performance bond. So the employer may require that the contractor provide a performance bond in a template form to be attached to the building contract, and from a surety to be approved by the employer. So for ease, generally the performance bond would be for 10% of the value of the contract sum, but for ease of the parties, a template form of collateral warranty, or the required form of collateral warranty, is often attached to the building contract. Sometimes you'll see clauses dealing with matters such as site maintenance to clarify that the contractor is to maintain the site in a clean and safe condition, and at the end of the works he's to remove all temporary works, plant, goods and materials, and also throughout the works not to create a nuisance, so no noxious foot noise or fume or unnecessary dirt around the site, and not to trespass on adjacent neighbouring properties. For some projects, we also see clauses specifically dealing with liability under the Waste Management Acts, and it has happened on particular projects that where there has been excess contaminated soil has been deposited in unauthorised waste facility, there have been question marks over the liability of the employer or the contractor for that waste. So the employer may say, well, I had given responsibility for this to the contractor, and the contractor might say, well, as I understood that the site where the waste was disposed of actually had planning permission for that, or it was an authorised waste facility. But there are particular obligations under the Waste Management Act on the producer of the waste and on the holder of the waste, and questions can arise as to whether the employer is the producer of that waste or who is the holder of the waste. So in order to avoid these issues arising, in some instances you may see a clause providing that as between the employer and the contractor is deemed to be both the producer and the holder of the waste, and shall bear all liability in relation to disposal of that waste in accordance with the requirements of the Waste Management Acts. As I mentioned at the outset, sometimes you will see clauses that are required to deal with specific site issues. So, for example, if there are specific constraints, as Siobhan mentioned, if there's limited access to the site, if you're working in proximity to utilities, overhead lines, railway works, sluice works, and then you may insert specific clauses dealing with the risk and who is to bear that, or specific requirements as to how they work in those particular areas. Likewise, in dealing with cranes and oversailing, so there may be a requirement that a licence be obtained in relation to oversailing on an adjacent property, and there may be conditions relating to the use of cranes. Then finally, some additional clauses, as Siobhan mentioned, Under clause 10, there might be changes made to deal with site management team, but if it's not dealt with there, well, then sometimes you'll see an additional clause requiring that the contractor maintain a specific site management team. So sometimes as part of the tender process, the employer will have required that the a specific site management team be put forward. So the employer will be anxious to ensure that that site management team with which he is satisfied is actually maintained for the duration of the project. And here, by inserting an additional clause, he can secure that. You may also see the insertion of boilerplate clauses that you would see in typical commercial contracts. So for example, a clause providing that this contract represents the entire agreement between the parties, that neither of the parties can rely on any pre-contract representations or warranties, that this contract is the entire agreement between the parties. They can't rely on any other documents, etc., that were exchanged between the parties prior to the contract. You may also see specific requirements in relation to notices, so that if notices are to be served on the contract, they're to be served either by email or by registered post, and setting out the names of the parties on whom any such notices are to be served. And severability requirements, so that if one clause is found to be lawful, it doesn't damage the rest of the contract. The balance of the clauses are still lawful and severable from the unlawful clause. So they're just boilerplate clauses that you might sometimes see inserted in the schedule of amendments. You might also see specific requirements to deal with the funder's project monitor and the project monitor's requirements. So the project monitor may want access to certain information or to be provided with programme updates for the duration of the project, or a possibility of attending certain tests or opening up of works. So you can deal with the funder's project monitor requirements in an additional clause. And then finally, you may also see a requirement in relation to health and safety, that a separate appointment be entered into by the contractor. And again, that appointment would be in a template form attached as a schedule to the development agreement. So I think that's all I want to say on the additional clauses. Siobhan and I will be happy to take any questions that you might have in relation to common amendments to the RII standard form. Thanks very much for your time.
Thanks very much, Margaret and Siobhan. And if you do have any questions, please post them into the Q&A. We have a number in there already. Quite a bit of interest. I suppose I might start with one that's kind of suitable for the day that's in us, about weather. Just a question on the definition of inclement weather, as it's come up on numerous projects for the person asking this question, and never seems to be clearly defined. I'm just looking for a bit of clarification around how best to define that.
Yeah, I mean, weather event is actually defined under the GCCC form of contract. And if you look at the tender and schedule under GCCC, it gives an explanation of how you can deal with this. And it includes reference to information from I think it's the most adjacent MET station. So you can draw on, if you look at the tender and schedule documents from GCCC, you can draw on the definition of weather event there to assist in defining that.
That adopting of clauses can be, from other forms of contract, can just be a useful way of covering some of these items. And it touches on something I think that you were talking about, Siobhan, earlier, in terms of insurance, and making sure that, you know, you've got appropriate insurances in place. So does adopting, you know, items or clauses from other contracts help to ensure you don't fall foul of that, and that's, you know, your insurance will remain in place?
And it's certainly helpful to look at other standard forms of contract, but I think that in terms of the insurance providers are very familiar with the common forms of standard forms of contract in use, and that's why I said that the actual risks that are covered are rarely amended without serious input from insurance providers. Certainly looking at the obligations which arise under GCC may be of assistance to you and your insurance broker in making sure that you have adequately covered any risk for which you are required to be insured. But any insurance clause always requires careful review and careful attention, because insurance is there for a reason. You don't want to fall foul of an insurance clause and be deprived of cover or protection.
Essentially, you don't end up invalidating your policy.
Indeed.
So question just on conditions precedent. Have either of you had any experience of the condition precedent rule being successfully contested and put aside?
I think we can both probably say that we've seen arguments being made, and the arguments are the most successful argument that I've seen is one centred about the contractor being aware, or when he should have been aware of, a particular event giving rise to a claim. The best and most sage advice, though, is if in any doubt whatsoever, serve the notice. Even if a contractor decides not to pursue a particular claim, the service of the notice will preserve the entitlement and prevent having a debate as to whether or not the clause is valid. Most of the condition precedent clauses that we would come across are well drafted and pretty much foolproof. So it is a requirement. It's better not to be having the discussion at all, simply for a contractor to serve a notice if in any doubt whatsoever.
Thanks. And the topic I know is very relevant to everyone who's attending today, is professional indemnity insurance. So can you talk to us a little bit about PII and runoff cover in particular, and how that can potentially protect around claims outside of the defects period?
Yeah, I'll take that one, Margaret, if that's okay. The contractual obligations that professional advisors or consultants appointed into a contract will have under their letters of appointment and under any collateral warranties that they provide to the ultimate employer or to his funder or his purchaser will include obligations to maintain those insurances for that runoff period, and may also include obligations to provide evidence of that cover during the limitation period. So there's no getting around it. If a consultant signs up to a letter of appointment, most of the letters that we see now are non-standard form. They are bespoke. They are letters of appointment put together by the employer's team. Will have this firm commitment and obligation not only to have the insurances in place at the time of the contract and throughout the defects liability period, but also to maintain those insurances for 6 or even 12 years. In most circumstances on large scale projects, the obligation will be to maintain those insurances for a period of 12 years. We spend a lot of time in discussion and debate around that particular obligation, and whether the consultant, first of all, is in a position to assume that obligation, and secondly, whether his insurers are prepared to permit him to enter into a 12-year obligation. The obligation can only be complied with if the insurance is available, and we've all seen pressures and constraints in the insurance market over the past number of years.
Absolutely. I can see there's an interesting question in the chat that I'll come back to in a moment, but just one that I might put to both of you, just in terms of trends. Are either of you seeing any particular amendments that contractors are particularly reluctant to agree to at the moment?
I suppose, where employers are now seeking to put all the risk in relation to COVID, both time and money, and put all of that risk on contractors. That's something contractors will try to resist, but they should have to bear the risk of all of that. COVID is clearly an entirely unforeseen, contractors and many parties will argue an entirely unforeseen event, and in those circumstances it would be inappropriate to try to shift all of the risk associated with that onto the contractor. So I think there would be resistance certainly to that one.
I think someone else made a point just in a related question about the time risk for contractors in respect of COVID and shutdowns, and how they're being required to carry some risk there as well.
Yeah, really the COVID risk, it should be subject to negotiation as between the employer and the contractor, is my view. It's not appropriate to shift entirely the risk of that to the contractor. But you know, it is very much you know, the employer and the contractor will be coming at this from very different angles as to who's to bear the risk. But if you were to look at it from a kind of what's fair, it seems to me that it isn't appropriate that you would ask the contractor to bear the entirety of the risk in relation to COVID.
I just move to a question that was posted in the chat earlier, just about clause 20 around independent trades. If that's been amended to remove the obligation for the employer to indemnify the contractor for any losses arising from independent contractors, do you see any amendments being made to clause 32 around the damage by use, occupation and possession by the employer to reflect that use of independence by the employer does not constitute use by the employer? It's a
I think it's a very good point. It's not a common amendment that we come across on a regular basis, and you know, whilst amendments to condition 20 are frequent, it doesn't always involve elimination of that particular risk allocation on the part of the employer. I mean, the amendment is intended to pass responsibility for coordination and interface to the contractor who is in control of all work going on the project. But it doesn't necessarily mean that the employer is absolving himself of all responsibility for any interference caused by direct contractors. And I don't see condition 32 amended on a regular basis. So I think it's an interesting observation, and I may look at the condition going forward, but it's not one we come across on a regular basis.
Thanks, Siobhan. I think we have time for just two more. I just might ask one about adjudication and one about adjacent properties. There are a couple of other questions. If we do have time, we'll get to, but if not, the contact details for Margaret and Siobhan are on screen, or you can contact myself or Michelle. So just in terms of adjudication, if an adjudicator is named under clause 38, is that binding on both parties, or is one party still entitled to seek a panel nomination of a different adjudicator under the Act?
Yeah, interesting point. I suppose, so that's a contractual provision between the parties where they agree that the particular person would be appointed as the adjudicator, but the Act stands alone. I'm not entirely sure if it was challenged how that would work out, but it seems to me you have made a contractual agreement that a particular person would stand as an adjudicator, but would that preclude you from separately applying to the ministerial panel? Would the ministerial panel have regard to the fact that a separate contractual arrangement had been entered into? I'm not sure. I don't know, Siobhan, if you have a view on that.
No, I mean, I take the same view. The only thing that I would say is that the courts are very reluctant to interfere with contract terms which are actually agreed between the parties. So I think that the court would have a very difficult balancing act between the standalone nature of the appointment process and the right of access to adjudication, and their overriding imperative, which is to protect the terms of contracts which people have freely negotiated between them. So I think I'd come down on the side that it is a binding agreement to appoint an adjudicator. And that would be the kind of the side of the coin I'd be on. But I really do not know what a judge would do with it.
It's an interesting one. All right. Just one final question before we finish, if that's okay. So in circumstances where construction work requires access to an adjacent property, so for example, if you're putting up scaffolding and it's not dealt with specifically or explicitly in an amendment, would that be the employer's responsibility to secure access agreement with adjoining owners? And if that's the case, should there be amendments making matters the responsibility of the contractor? Is that appropriate or reasonable? Again,
Margaret, the very first thing to say is that stepping on somebody else's land, stepping on adjacent land without a license, without permission, is trespass and can be stopped immediately by an injunction to prevent you from doing so. So you're not permitted to erect scaffold or to stand on somebody else's property to apply a render without their permission. Where responsibility lies for obtaining that permission, I would say that that responsibility under the RIAI form of contract, the standard form, probably lies with the employer, because the employer provides to the contractor access to and a license to occupy the site only. So my instinct is that that responsibility would lie with the employer. But in such circumstances, if the works required that kind of activity, I would fully expect that the employer's team would identify that at an early stage and shift contractual responsibility for the contractor for obtaining that license and that consent, and fix the contractor with full responsibility for any delays arising from a failure to do so.
Thanks, Siobhan. I think that brings us nicely right up to bang on 12 o'clock. Just to mention to everyone, the slides and recording for today are going to be posted on the website within 24 hours, and a link will be sent to all attendees with the slides and recording as well. I'd just like to close by echoing some of the messages coming in from attendees to say thank you to Margaret Alston and to Siobhan Kenny, and thank you to all the members for joining us today.
Thank you very much, James, and thank you for your attention, everyone.
Thank you now. Goodbye.